So, first of all, we need to be very clear that we don't comment on individual cases or transactions, and we don't comment on comments. Those are the rules, as you know well. But I can recall the general rules as they apply to these types of cases. So, from a security and public order perspective, Member States do retain the responsibility to implement restrictions to market freedoms through their national laws on investment screening. This being said, and this is very important, restrictions to the fundamental freedoms are only permitted if they are proportionate and based on legitimate public interests, and most importantly, insofar as they do not breach EU law. So the Commission has requested more information on this case. This procedure is called the EU pilot. This was the crux of your question. The Commission applies the EU pilot dialogue whenever it is considered useful to have an informal discussion, but in a more structured way, with the Member State on potential questions regarding compliance with EU law. So I hope that gives you some idea of the divisions of responsibility, and we can't say much more for the moment. We have to let the process play out. So, as I just mentioned, we've requested more information via this EU pilot. It's up then to the Member State to provide that additional information, and then we have to make an assessment to see if the European law has been correctly applied by the Member State. So it's really as simple as that.
Thank you.